Yes, sir. We can start.
Thank you, members. Thanks for joining the session from IIA Madras Chapter. I'm Ravi Bir Raghavan, President. Uh, Welcome to the session. It's a very interesting topic today from a data privacy digital protection bill, which is now act as of August 23. And there's a lot of interest shown in this subject, and especially from the chapter perspective, we are very happy to host Mr. Andrew David from Zoho Corporation, who's the compliance head and compliance manager and data privacy as well. So, one of the new things happening, there was a lot of legislation. This was topic introduced last year, but it's taken some time to go through. And very interestingly, what has been introduced in India is the act now, but slowly the rules will start to get notified in the next few months. And once the act becomes as executable as it is, it's going to be very interesting how companies and also others follow this and how it's going to be interpreted. And a small introduction about Andrew. Thanks, Andrew, for coming on the call and hosting us and spending your valuable time. So, a small introduction about Andrew. He leads the data privacy at Zoho, and Zoho is no introduction. It's one of the biggest SaaS giant clients in India, and he's been associated with Zoho for 7 years, and he's graduated on bachelor's in engineering, first on development and now on privacy. And then he's a lot of assessments through the company, which is all of us know how Zoho has grown, and I don't need to introduce Zoho as well. He's a certified ethical hacker, CIPM, certified privacy, information, etc. at a very young age, and he's a very expert. I had a lot of discussions the last few months on with them, and it's a very knowledgeable person. I'm happy to host him today. And he's also a GDPR expert with various compliance programs. And he'll be running through this session with a lot of introductions on the topic, with a lot of case studies, how they implemented in his own client. And he guest lectures in quite a few colleges on security and data protection. And very passionate about the project because privacy is a very big topic today. It's a very sensitive topic as well. Thanks, Andrew. And I have Karthik also Ramchandran from Director and Deloitte, and I have Anup on the call. So Karthik will be hosting the session. I'll also be on the call, but Karthik also will be checking in. Just one or two good ethics. If you have any questions, put it on chat box. We'll have Karthik. We have Andrew to answer now and then. But it's a 2 hour session, so feel free to chat. Put on the chat box. Whenever the chance comes, he will be responding. If there are more questions beyond 8 o'clock, happy to take the thing. This is going live recorded, so please avoid any political questions or any sensitive questions. We'll be happy to take it offline with Andrew and Karthik. Thanks once again, Andrew. Welcome to the session. Thanks, Karthik. And Sarvanan, thanks again to host. All yours, Andrew and Karthik.
Thank you, sir. The pleasure definitely mine to be part of this esteemed chapter, to be able to present on a very interesting and very important topic. So before we start, Karthik, do you have, would you like to pitch in for anything, or am I good to start?
No, I think you're good to start. Yeah, I'll pitch in. Yeah.
All right. So, hi everyone. Good evening. Probably a good time to talk about this topic today. So I was reminded of what happened on this day 5 years ago. Any takers, probably if you're listening and are on chat, if you can remember, at least in the domain of privacy, or if you at least heard of that, can you recollect what happened on this very special, it's a very significant day, I would say, or significant milestone that was reached 5 years ago on this very same day. And it happens that we are discussing on a very similar topic, which is privacy, 5 years later. So if you know, please put it in the chat, like any guesses, and you don't really have to be accurate, but just to start this up in a very nice way. So if you know what happened, what was that landmark milestone or judgment, I'm giving you the keywords, that happened 5 years ago on this very same day. It came out of the court the very same day 5 years ago, that revolutionized what privacy is, what data protection is, the right to privacy, constitution, all of that were part of that judgment. So I'm just going to wait. Lovely. Yes. Perfect. So Saksham has given the right answer. So what happened is, Andanal Nyabagam, on the day, right? It's a time to remember. 24th August 2017 was when the Justice case, Swami versus Union of India case on the right of privacy, whether it is a constitutional right, whether it's a fundamental right, was arbitrated, and the judgment actually verdict was actually pronounced on this day. And it's incidental that after 5 years, they're talking about a bill that protects the privacy of people who are in India. Right, so it's a very interesting topic. Like, I've been associated into privacy for about six and a half years, right from when all of these things started to uh, take up the center stage rather. So I was in charge of taking care of GDPR at Zoho. That's how I even joined as part of that. So yeah, I'm not a lawyer, so don't take my advice to be a legal advice. This is not legal advice. This will be based out of experience. It will be based out of observations, opinions that I have made, and obviously case studies that would be helpful for all of us to assess and learn together. So this particular case changed the way that privacy was viewed in the Indian market, in how India visualized, conceptualized, or established what privacy is. So, as you may know, the Constitution of India does not specifically mention the keyword, or the title "right to privacy" or anything of that. But this particular judgment, based on two previous judgments before this, they came to a very solid conclusion that right to privacy is a fundamental right. So what is privacy? Privacy is something that many people take for granted. They usually think about just data protection aspects of privacy, but what is the fundamental right of privacy? It is usually enshrined in fundamental rights. It is usually enshrined under human rights. Your right to life, your right to freedom of speech, your right to freedom of religion, right? So in such a manner, it's a fundamental right of a person, and it is a human right. That's what the Constitution acknowledges, and that is what this judgment actually brings. So 5 years down the line, things have changed. So we would be looking into the history of how it actually evolved, the different bills in the past, right, from 2018. So we have given a lot of, from our company as well, given a lot of inputs. Many of us, right, so would have given inputs to the governments, the bodies, into what we think about the bill in 2018, 19, around all those times, how it actually evolved. And there is no bias in my statements, but just bringing you the facts of what I have seen, what I feel is good in this law, what is bad, and how it can help businesses, how it can help individuals, people such as us in exercising our rights. So yeah, the right so far, the act so far has been published, but it has not been brought into force yet. Like Ravi sir said, it would soon come out through way of notification of when it would actually come into existence. So that gives us sufficient time. What I'm expecting is about at least 9 months time. So let's estimate it to be around, let's say, June next year is when this act would actually come into practice. So we have sufficient time to orchestrate our projects in such a way that can comply with what the specifics of this law are. Most of you might have worked on many other legislations across the world, and so did I. GDPR, many US local state laws, the CPRA, the Brazilian law, Singapore law, Malaysian law, Philippines law, Australian law. All of these laws are something that our company has worked on, and I've had the privilege to lead those projects. So having come from such a background, I see a lot of similarity with how the law is positioned in the overall space of privacy and data protection. Obviously, the first bill that actually came out was a lot more stringent. If you had the opportunity to read, you would have seen that it is a bit too complicated for the Indian diaspora, at least in India, the way that we see certain things. Like, for example, caste was a sensitive information that was present in the first version of the bill in 2018, around that time. But the current act that we see does not have a definition of what is sensitive personal data at all. But obviously, we already know that in 2011, we have the SPDI rules that are already regulating how to handle sensitive personal information like biometrics, sexual orientation, all of those uh, sensitive information as per Indian laws, right? So we see a lot of difference of how it has evolved from the past to now. But let's talk about facts. Let's talk about what we can do and what the law is actually talking about, how it can contribute to us as internal auditors, as lawyers, as security specialists, whoever we are, how it is going to go into practice and how it fits inside an organization scheme of events, how to strategically place our compliances around compliance of this law, and what existing frameworks, what existing legislations, what existing past achievements of your company you can actually leverage to comply with the Indian law. You could be a startup, you could be part of a startup, advising a startup or a large enterprise. The level of compliance, as you know, is going to obviously differ. The amount of effort that is required to comply is obviously going to vary over time. So that having that understanding, that basic knowledge that this is not going to be one size fit all approach, but this covers all the basic aspects and how we can take it forward as part of our corporates, as part of our personal lives, as a resident in the Indian territory. So to just give, I would run through the slides, yes, but at the same time, I would do a lot more talking, looking at examples. So just about the scope and applicability of the law, you might have had the opportunity to read some of those advisories or some of the WhatsApp forward messages about the law. So to whom does it apply to? We usually call it as, in other laws such as GDPR, we call it as the material and territorial scope. Material scope is the objects, the substances to which it applies to, and the territorial scope is in what region, physical boundaries, geographical boundaries it actually applies to. So that is called scope and applicability. Like, for any audit program, we have a scope and an applicability. In a very similar way, a law also has scope, applicability, exceptions. That's going to be the case. So the Indian Act, right, the DPDP Act, that's how I'd be referencing it after this. The Act talks only about digital personal data. So that is something that has changed. That is one of the things that we will see as some change between the initial drafts versus the current Act. So any data that is held in a physical medium, such as, for example, a data that you write on paper, that, for example, my phone number, my email ID, my address that I write on paper and I present it to any one of you, that data is not going to be regulated under this law unless you further digitize it later on, which is, for example, you put it in your CRM system or you put it in any of your mailing systems or anything of that matter. So just because you go to a bank, just because you fill up a form that is physical in nature, obviously now things have become digitized, but still many banks or many applications involve paperwork. So what happens to the paperwork determines whether that particular data that you're filling up in that form is going to be regulated by the law or not. So if you convert that paper format into a digital format, such as could be scanned copies, not necessarily a text field, not necessarily a phone number field, such as in a form, but even if you scan it and upload it and use the data, that is going to come into the ambit of the law. So data that is in digital form is called as, is what is being regulated by this law, and therefore the name of this act itself goes back to the title. Going back to the title, it says digital personal data protection, right? It is not just personal data protection. So if you look at countries such as Singapore, Malaysia, Philippines, all of their laws have PDPB or PDPA as their title or their acronym, which is personal data protection or privacy data, or something of that. So, but here we have DPDP, very different, very nicely named also, but given the caveat that it applies only to digital personal data. And it applies only to data that is processed by automated means. So if you're manually processing the data completely without any automation, what is automation? Obviously, we have to look into the law for that, but just to give an understanding, if it involves computer systems, you can think of that to be automated. If you are doing everything on paper completely from start to finish, nothing involves any digital format, then this goes it goes beyond the applicability of the law. And it applies to processing of personal data that within and outside Indian territory, meaning that data that is collected within India, such as our, let's say, our KYC forms, our visa applications or passport applications, any other identifier that we apply to, any application to any company that we give as part of our hiring, and all of that comes with the data that is processed or collected within the territory of India. The other condition of territoriality is called extraterritoriality. Reason being, it extends further from the boundary, the territory of that given country. It's called extraterritoriality. I don't think it's extraterrestrial, it is extraterritoriality, which means above or more or extending beyond a given territory. So processing of personal data outside the Indian territory, where such as, let's say, a Malaysian company or a Singapore company, such as recently I saw the ad of DBS Bank. I was back in Singapore a few months ago, where I saw DBS Bank very much being used everywhere. That was one of, like, let's say, like HDFC Bank of India. DBS Bank was a very common, famous bank. Suddenly, after coming here, the last 1 month, I'm seeing more ads about DBS Bank. I was in Bangalore last week, so there I saw about DBS Bank coming here. So that case, obviously, they will be opening entities here in India, definitely. But even more so, extending further beyond, since they are targeting India or people in India, since they are targeting operations in India, since they are wanting to provide goods and services to people within India, DBS Bank now has to comply with the Data Protection DPDP Act, right? So that is called extraterritoriality. Just because you have that intent to provide services and goods to people within India, you come under the ambit of this regulation. So that is about scope and territoriality. Okay, there is one question. I will take that up now. It's a data that is scanned is digital, definitely digital, because it is being converted from hard copy to a soft copy. Soft copy involves computers or phones or any digital device. So it becomes digital data. So if you scan, let's say, a KYC document, or you scan an agreement, a rental agreement, or if you scan your medical reports, if it's given to you in paper, generated on paper, written on paper, but you scan it and you upload it to a system such as part of your processing operations, that becomes digital data. So I'll go into the exceptions when I say how it differs for personal usage, such as, for example, let's say I'm living in a rented house. The owner gives me a receipt on paper. Now I take a photo of that and I store it in, let's say, my Google Drive or in any such storage mediums. That is digital data. Is that regulated by the law? No. Why? Because the law allows for something called as exceptions. As much as you have scope and applicability, now that the data has been digitized, it does come under the ambit, but you go into the exception, which is the next category, where you can say, I'll probably, okay, after the case study, okay, after the case study, I'll go into that, the exceptions, in which cases the law is not applicable, such as for personal reasons. It's also called as domestic purposes, similar to how the GDPR says, for example, you have your phone contacts on your own mobile phone. That is not regulated by the law because it's a purely domestic household purpose, right? So, but if you do it for the purpose of business, if you do it for the purpose of a commercial transaction, if you do it with an intent of providing a service to someone, not in your personal capacity, it may come under the ambit or come under scrutiny of the DPDP law, right? So I am calling my parents and calling whoever on my own personal capacity. I'm storing their number on my phone. I am WhatsApping them. I am telegramming them. That does not come under the law because that is purely domestic or purely household. It's an exception given under the law, right? So just understand this a little more. I'm just going to give you 5 cases. Probably I would love if you could respond in chat about that, whether you think the law is applicable in the situations or not. So this is the first case study. I'm just putting 5 questions on screen. I would love to have your answers. So you can just maybe comma separated values. You can type it on chat. Yes, you can just say YN, yes or no, right? So you can just put it on chat. Let's see how many of us can understand it given the scope and applicability we just discussed and the exception as well. How do you think it applies in this given context? So I'm just giving you maybe 10 seconds. Just type yes, no, whatever the combination is in chat. Okay, while you type that out, there's another question. What are the similarities and differences between GDPR and DPDP? Good question. That is something that I'll be summarizing halfway through the slides. At that time, I'll just point you to the specific differences, compare it with other legislations also. It may not be on screen, but when I come to that slide of concerns or issues, there's a slide that I put. At that time, I'll explain these differences.
Yeah. Hi, Narayan. Sorry, I raised my hand only to say the same thing. Chat is was disabled.
No problem. Surrounding chat is enabled.
1 second, sir. Yes, sir, the raised persons are asked to unmute. They are allowed to speak, sir. 1 second, sir. I'm updating.
No, I think one of them had done it by mistake, so maybe we can skip them also. Not yet applicable. Okay. I think chat would work the best here instead of Q&A because. Okay. So Narayanan has given answers inside the Q&A window itself. Chat. Okay. I think there's still some issue. Chat disabled. Right. Chat attendees.
1 second, sir.
I think I've changed it, Sarun. Sorry, attendees, participants. There's some small issue, I think. But I think I've enabled the chat. Can one of you try if you can? Yeah, I think it's working. Good. Thank you. Perfect. Okay. No, yes, no, yes, no. Business purpose. No, yes. Okay. Very similar answers. Good. No, yes. Okay. Good. I'm seeing a very similar trend of answers. Good. Okay. Let me just run you quickly through these different use cases. Right. So the first one, as we know, given the applicability, it's only for digital content, digitized data. Right. So obviously the answer here is no for the first one. Second, the organization is in the path of digitizing records. Yes, your answer is correct. The answer is yes. Third, you're obtaining data on paper and you're making calls. So that is one question that I assumed many would answer probably later on is, will I be getting less number of calls from all these data brokers such as insurance companies, loan companies? Sir, உங்களுக்கு loan வேணுமா? நாளைக்கே கொடுத்துறோம். We should will those calls reduce? That's a question that I feel many would ask. So the answer here is most likely, given the way that data is being handled these days. Nothing is fully on paper, at least for all these insurance companies and these banks, right? So they export data, they get data from various sources. So I've actually taken that up as a challenge sometimes, and I've even called up them, or when they call me, ask them, what is the source of this data? Because in GDPR, if you actually see Article 14 of the GDPR talks about providing the source of the data from where you obtained it. So obviously that GDPR is for Europe, not for India. Now that this act has come, the law does not specifically mention that you have to provide the source of the data, which one example between GDPR and DPDP, the difference between them is if you collect data about someone indirectly, like for example, if I just not ask someone for the data, such as through a form or something, but rather I scrap it off the internet, or I download it from some data broker tools, or I go to some local Xerox wala shop and I pay some money and get some contacts, right? So that is still possible in India or in black market, whatever the case is. That data most likely will be these days, it is digitized. So it will come under the ambit of the law for the most part. Let's assume it is for digitized data, but here my case here is it's obtained on paper. So it is the reason why I put it specifically was to create confusion, is because the organization who's getting the data is getting it on paper, but where did the data come from? it could be from a digital source. So you have to trace it back to the origin, the source of that data. So if it goes back to, let's say, your Kobe Palamudin Nilayam, or any other such entity, right, who collects, or this any shops, H&M, Alan Solly, any shops you go to, they ask you for your phone number. So they are taking the data in a digital format. They are not asking you to most likely fill up a form, right? So that very entity who has obtained the data on paper and is making calls, you would still unfortunately receive calls from them. But you now have the right to ask them your right to access data, right? It's part of your RTI that is given under this law also, right, to information whether they have your data, what data they have, but unfortunately you cannot specifically ask for the source because that is not provided for explicitly in the regulation, right? So that is something that we might be missing, but who knows, an amendment might come anytime, maybe next year or year after that, depending on how it's being adopted. So for case 3, let's assume the answer is no, right? The law will not apply because they are applying data on paper and they are making calls. So let's assume that in that case. Case 4, data of an Indian collected in Singapore. I see a common trend here. Many have said yes, but unfortunately the answer is no, because the law does not apply to Indians, right? It applies to data processed within India or collected within India, right? So let's say the Singapore bank that I mentioned, the data is collected in Singapore, right? I am an Indian who has gone to Singapore. I am purchasing something in a shop, and there I have to give my phone number. I have to give my, let's say, my local residence address, wherever I'm staying, my hotel address, right? I am an Indian, or for the sake of visa, I have given my data to the Singapore embassy, right, to get me a visa, right? So in those cases, obviously for the visa case, law will apply. But if I am physically present in Singapore and I'm making a local purchase and my data is being collected, law will not apply in that case, right? So data of an Indian is not fully regulated by the law. It is not about Indians. It is not about citizens. It is not about immigrants. It is about anyone who is in India, right? So it is, you can think of it as data collection from India or data processing in India. That is going to be the scope. That is again the same problem with GDPR also. They share similar problems. GDPR says for anyone in the EU, INTHE EU. In the EU simply means that you are physically present in the EU. Let's say you are traveling on a business meeting to Europe. Most likely the law will apply to you there as well. So far there has not been any major lawsuits. There has not been any major case loss. But it is understood that in the EU significantly means that you are physically present in the premise, inside the territory of that particular country. But if you look at California for that matter, they say residents of California. They are very specific about residence. What is residency? They go back to, they are pointed to another law which talks about this immigration and domiciled in that local country and all of those particular factors. So some laws such as Californian law talk about residency status as being one of the indicators for, I think Karthik, I'm just going to mute you. There's a feedback. Thank you. Yeah. So that being the case, we don't really have to, in Indian context, let's not think it's applicable only for Indians, right? It is applicable for, brings me to case 5. The data of a foreigner that is collected for a hotel reservation, right? I see a common trend here saying yes. So the answer is yes, because let's say one of your counterparts from America or Dubai has come to India, who's checking into, let's say, Taj hotels or going into ITC hotel, any such hotel like that. So there they have to fill up that form, or they have to get that reservation for that hotel, right? So the hotel is now a regulated entity under this law. Regulated entity in the sense they have to comply with the law. So data of a foreigner that is collected in India or processed in India means that most likely the data is for the purpose of providing a service in India, right? So the law will apply for case 5. In case 4, it does not apply. So the answer in order is going to be no, yes, no, and yes, right? So those are going to be the answers for this case. So I hope you are now having some idea of how it applies, but again, lawyers, the way that they interpret in different cases would be different. So we just have to wait and watch only when case laws come, that is what they told during GDPR time as well. Only when cases are being vada-defied in courts, that is when the real truth comes out, right? So only when case studies come, only when case laws come, you'll actually see how it implies in practice. But for the most part, you can be pretty safe with this understanding. Okay, there are Q&As. Let me just have a look at that. Okay, all of these are just chats. Good. Okay, so what data is personal enough? So this is again a trivia for all of you. I want you to take a guess, right? Some of you might be knowing. Take a guess as who owns this car? Whose car is this? If you can take a guess, put it in chat. Amitabh Bachchan. Wow. Amitabh Bachchan is in Tamil Nadu. Wonderful. Okay, I see a lot of Talabadi fans. Right. So if you actually look at the license plates, it is TN07BV0014. Just one simple lookup in Vahan app or car info app will give you the results. Joseph Vijay. Okay, I did not mask that. I didn't obfuscate that. I did not put the star, but that is how it is on record. I don't know to what level of privacy they wanted to do this, or the RTO even permitted that. Ideally, it's supposed to be the entire name. Let's not get into that. But it belongs to Joseph Vijay, which is actor Vijay, right? So simply looking at the car or the registration plate, you know that it belongs to an actor. So what data is personal data? If you go into definition, it says any data about an individual who is identifiable by or in relation to the data. Simple as that. Any data, that is I underlined the key terminologies here. Any data, right? So again, some of you might have that question, like how IP address is personal data or not. In Indian context, whether it's personal data or not. If that data can identify you directly, such as by or in relation to, such as this simple search that we just did right now, just looking at a car, looking at their license plate, and making a simple search in a public database, I am able to identify who that person is, right? So even if it is not a famous person, such as an actor here, even if it is my car, you can just put my number plate on the tab and you can see my name, very basic data at least. You can know who that person is, who's the owner of the car. I'm sure many of you would have already tried that, right? So your car number also now becomes your personal data, like my hairstyle becomes my personal data. In California, if you see, very interesting words would have been used, very interesting data has been recognized as personal data. They use the terminology personal information. They don't use personal data, but they say voice patterns, the way that you actually speak. You know, if you have been listening to me for the past half an hour, you know where I pause, what words I stress, whether I talk in Indian English accent, whether I talk in an English US English accent. You know all my trends, right? So that's a voice pattern where I break, how I stress certain points. So that is my voice, right? So based on my voice, you can recognize me. Or it could be your gait. Gait is basically a walking pattern. If you actually closely observe your neighbors around your house, even from a distance, you can identify who they are just by the hairstyle. Like there are some people who wear the same shirt. If you take Mark Zuckerberg, he wears the same t-shirt, same gray t-shirt everywhere, right? So even if you chop off his face from the photos, just by looking at his other part of the image, you will know that it is Mark Zuckerberg, right? So similarly, your neighbors also, depending on certain of their characteristics, you know that that person is them without even looking at their face, without knowing their name. You will know that this person is residing in this flat, right? So any data that can identify you, who's identified by that data, such as your name is your by data. By data in the sense it is your something that belongs to you, right? Or in relation to, in the sense it does belong to you, but probably not directly. So GDPR's definition is even bigger. This is quite expansive actually. Whether it is good or bad, only time can tell. But if you look at Californian law for an example, they are very specific. If you look at US regulations in general, breach security regulations, state security regulations, state breach notification regulations, state act regulations, sorry, state privacy acts, such as Virginia State Act, or it could be the CPRA, it could be Washington Privacy Act, it could be anything that you take. Texas bill is also coming up. So, all of that, if you see, the way that they define the personal information will be very specific. They'll also give you examples. They'll say that, for example, this voice pattern that I said, or this walking pattern called gait is an example. They are very specific. They also, in this breach notification laws, they say that any data, your full name, including, they also have a plus in between, such as your name plus credit card number, your name plus an identifier, a name plus a financial account number, something like that. So they are very specific. That is the US standard. But the European standard is very broad. India seems to have adopted the European standard in a way, because it's a large definition by itself. One good thing is, if you look at the keyword individual, individual is again defined in the law. Let's not get too legal here, but individual is basically a living person, a natural person. But if you look at South African law, they also include juristic persons. Juristic person is basically a legal entity, such as your company name, your company's phone number, your company's address. That is also personal data in South Africa. But in India, that is not the case, because they have mentioned individual, which is one way good for us. So what would identify you? Direct identifiers, indirect identifiers, strong and weak identifiers. These are some categories or some technology keywords that we use. Direct identifiers, like for example, you know me by name, you know me by face, probably you'll know my phone number, my email ID, all those values you would know about me. It belongs to me, it is of me, right? So that's a direct identifier. Indirect identifier, such as the car example that we saw, it is an indirect identifier. Using this, you can identify a person. Strong identifiers are very specific to a person, such as, let's say, my biometric could be a very strong identifier. My name in full, right? My name, Andrew David Bhagyam, that's my third name. If you just put Andrew David on Google, you'll find a lot of results. But if you put my full name, the results will be fine-tuned to my listing, such as some blogs that I've written or some videos that I've participated, something of that nature. So that data is now a strong identifier. Just some of your names also might be in that method, like very unique names. For example, your name is very unique in India's geography. It is very unique in India's or global name also, because of, let's say, your spellings. Probably, let's say your name is Akash, right? Most of them have it AKASH. Simply, some have it due to numerology or those other factors. They might have it AA. I've even seen some people have AA, double K, right? So given all these uniqueness, the more uniqueness you have for yourself, it's a strong identifier for you, right? So weak identifiers are basically a combination of data about you, such as your role could be a weak identifier. Who's the CEO of Zoho? It's Sridhar Vendu, right? So similarly, these are weak identifiers because they are used in comparison. They do not directly name a person. They do not look at a person's own personal data, but they have some information about that person. So again, this is a very huge concept that I don't want to go further, because there are also other data called as data about you, data of you, data from you, data inferred of you, right? So there are different categories there itself. So inferred data is about your opinions. That actually brings me to Australian privacy principle, Australian law. According to Australian law, any opinion about you, that also constitutes personal data. Like, this person is tall and sharp, very wise, has gray hair, doesn't have one teeth. All of those are identifiers, right? So we know that is all personal data. But my opinion about somebody, be it subjective or objective opinion, whatever that is, in Australia, that is categorized to be personal information. So you see the diversity of how personal data, that particular definition, can actually vary across geographies. But coming back to India, now you know that it belongs to an individual. So any information about you which can identify you directly or indirectly, such as by or in relation to, is personal data, right? So that is a huge, huge definition that we're actually looking at. I already mentioned that, so I'm just quickly going through, going past this. Is exemptions to the law is domestic or personal purposes, which you already mentioned, like using some data for your own purpose on your own personal capacity, like that is excluded, such as your own contact list, your own notes that you've written about somebody, you know, all of those kind of information, or data that is present in record more than 100 years, such as going back to 100 years, 1923, right? Any data that has been there before 1923 is not under the law. I don't know for what purpose. Probably is just to have some restriction over time. Whether it applies to deceased people, such as people who are dead, who are not alive, potentially yes, right? So the law is a little silent on that, but most likely it will be applicable, is what many of the experts, privacy experts, actually reckon, right? So data that is of a person who is no longer alive is still under the ambit of the law. And why am I saying that? Is because when we look at the rights that a person has, you would most likely understand that there's the right called right to nominate, where in your death or your incapacity, such as in a fatal illness or in a situation where you're not able to be in your normal mental being, physical being, right? So you can appoint someone to exercise rights on your behalf, right? So deceased is also as part of that, incapacity or death, right? So most likely your information, even if you are not alive, if it is obviously not more than 100 years old, will still be regulated under the law. Okay, I'm going to take one question now. Is what's the difference between personal data and personally identifiable information? Okay, very good question. So you can see two stark differences, or let me put it in a visual perspective. You get an Amazon box when you place an Amazon order. Let's say you place a phone, order for a phone. There will be a phone box, there will be the phone itself, there will be the phone box, and there will be the Amazon box on top of that, right? So personal data is a bigger box. Like you can see, your car number is personal data, but your car number is not personally identifiable data. It is not data that is identifying you. Most likely directly is you can take it like the space of AI ML also, right? So AI is a huge space. Under that you have machine learning. Under machine learning you have deep learning, right? Under that you have this generative AI and all of that. So that's a huge box coming into different smaller boxes, comprising of smaller boxes. So in a very similar way, just to put it in summary, personal data is a very huge definition. It can include anything and everything about a person that can lead to a person, lead to identifying a person, such as IP address is not PII. It is not personally identifiable because you don't own that IP address, right? It is assigned to you for a temporary purpose, but it is personal data just because in one way it points back to you, right? So personal data is a huge bucket, huge box. Personally identifiable information is usually the smallest box inside, because it is data that directly belongs to a person, that can directly it is of that person. It is like derived data, such as how you are performing at your work is personal data, right? But it is not personally identifiable data, right? A person who always comes late to work, if you have the title, or a person who always comes early to work, it is not PII, but it is personal data because it is points to you in a manner, right? So that's I hope you get the difference between that. So who are the different actors? Okay, there's a Q&A. Yes, I will be telling that. What is it? Who is a data fiduciary? I'll be covering that. Right. So who are the actors? Any law will have actors. I like to think of it as actors. You can call it different roles, different offices, different capacities. There are different words to say it, but I like to call it as actors. Who are the different people in that entire act? You call it as an act, so I call it as an actor. Right. So a data principal, data fiduciary, processor, and the board. I'll just show you some examples of how what its definition is and why they have mentioned it and why it is beautiful. Their selection of words, right? What fiduciary? Why have they chosen fiduciary? Right? So it's very beautiful, and I'll give you an understanding about that. This is what Google actually tells you, and which is true. If you go back to the term fiduciary, it generally draws line to financial regulations. You often find that word fiduciary in financial laws, any of the RBI laws or anything like that. Even in the US New York Financial Act, right? You find the word fiduciary. who is the fiduciary is a person or an organization. I'm just reading it from the screen, that acts on behalf of another person, or putting the more important part is putting their client interest ahead of their own, with a duty to preserve good faith and trust. So if you actually look at the difference between GDPR, again bringing contrast here, GDPR says data controller, but Indian DPDP says data fiduciary. Why the difference? What does it even matter? Controller is simply one who determines what and how to do with the data. Like for example, you have your keyboard at home, in your laptop, right, or in your PC. You actually type on that, right? So you are giving some instructions. There is a microprocessor inside that is actually doing that conversion between the ASCII value versus what key you are pressing and all of that, right? So data controller is simply one who determines what to do with the data. Like simply you can think of it as a decision maker, right? How and what and where I want to process data. It's basically how and why. Data controller simply takes decisions on what to do with the given data. A data processor, as we know, executes that on behalf of that controller, right? But why have they introduced or used the word data fiduciary here in DPDP? Is because of this very very nice concept of interest or intent, or you can't simply go with the decision. That's what they're trying to say. You take a decision, whatever happens to the data, done. You cannot wash off your hands, right? You do it in the interest of that person. Whatever decision that you take as an organization or as a person while processing someone's data, you put their interest first, right? You are not selfish in your decision for your own business. Rather, you consider that individuals are also called as data principal. I'll again come to who is a data principal, but you first put that person's interest first with a duty. You have an inbound duty to preserve that good faith and trust. Just because you have a service relationship with your client, simply because you have that sort of a contract or that kind of a relationship with them, it does not mean you can do anything with the data. Does not mean you can simply take a decision and leave it to however it goes, right? You should do it in their interest. You should put their interest first, and you should do it in good faith and in trust. You should maintain the trust relationship. That is the difference between fiduciary and a controller. Controller simply takes decisions, decides what to do with the data. But the beauty of the word fiduciary is that you, as an organization or as the person who's deciding how to process the data, you put that other person who is the party of the data first, and you do it in such kind of a manner you have that trust. Now they can trust you. The trust relationship actually comes in a fiduciary relationship, right? Obviously, legally, there are many ways of understanding that, but I'm just bringing out the beauty of what it means. So also, I try to find out, being a Tamilian, I wanted to find out what fiduciary in Tamil enna solla varanga. What does it mean in Tamil? It means nambikkai kuriya, right? So that is the beauty of the word fiduciary. Fiduciary means nambikkai kuriya, in the sense you are trustworthy, that someone is trusting the data with you. Don't simply, do whatever you think is good. Do whatever is good for the person's interest and maintain the trust relationship. So that is the beauty of the word fiduciary. So yeah, drawing comparison with other laws, I'm just going to go with 3 parts of the world, like how I was doing so far. One is the western side, a little western, which is going to be Europe. You can go into, I'll be quoting about US, little more from the eastern side, which is Singapore or Australia, as it fits, right? So in Europe, they call it as the controller, data controller. Many of you are familiar with that term. In California, they call it as a business. A business determines what to do. So they don't use the word controller, they don't use the word fiduciary. In Californian law or New York law, New York privacy law or Washington privacy law, Texas law, they do not, Virginia law, they don't use the word fiduciary or controller, they use the word business. That's how they call it. And obviously the definition is different, slightly different. In the other parts of the world, they also stick on to controller in many cases. Some they say business, some they say organization, as simple as that. So that's how it differs across the different geographies. So why do they use the word principal? If you, again, going back to GDPR, just giving you a contrast, they call it data subjects, right? Who is the data subject? anyone who's a subject of the data, right? That's the beauty of the definition. Who's the data subject is someone to whom the data belongs to, or someone whose data is being used, right? So they are called as a data subject. But looking at Indian law, why have they called as a data principle, right? Obviously, this is my take on that. This may not legally right. This is just my take of how they have structured this word to be a data principle. Obviously, there are historical reasons why they have taken the word data principle, but just my take on this. Principle means adibar. In Tamil, it means adibar. Adi means ruler or in charge, right? So, our school la kuda principal irundhirupanga. In our schools, we have headmasters, principals, right? Principal is the one who is in charge. So, data principal is the one who is in charge of their data. Let's not confuse it with data custodian. That is a different story. I'm talking about the person. You are the principal of your data, right? You are the one who determines. You are the one who owns your data, right? So you are the authority over your data. So Adibar is a ruler over your data. So data principal is simply you, a person whose data is going to be processed, right? So data subject is equal to data principal. Data controller is equal to data fiduciary. That is how it is currently that we can see. Going a little bit into the security domain, if you look at this Bell Padula model and all of those security models, right, they use the word subject, object, principle, and all of that are some inbound attributes. Principle is an attribute or identity, right? So, for example, read access is going to be a principle. Subject is going to be collection of all of that, right? So, attributes or principles, identities are called or referred to as principles. Subject refers to a collection of a group of principles. Right, so data subject is anything all in your wholeness. Like if you look at Europe, they call it data subject, which is a collective representation of all of your attributes. But the beauty of data principle here is it is all your specific attributes. So I'm just appreciating the beauty here. This is just my take, like I said. So the principle simply means they are referring to you in your individual characteristics, in your individual beauty, in their individual attributes, not as a collective, just like not seeing you as a human being, rather appreciating who you are as a person, right? So this is just my take on that. So again, just for the sake of knowledge, data principle is equal to the person whose data is going to be processed. Okay, we're going to understand the unity and diversity, a little bit civics topic, but not really civics. The civics is more, this unity and diversity is about unity across the different laws, like how we've been doing from the start. We've been comparing different laws across the world. So if you take any law for that matter, this is something that you can know, right? Like how security is comprised of these three pillars. The CIA, privacy has principles, right? There are about 7 odd principles for privacy. I don't want to put it on screen, but 3 or 4 of that. Or if you read any privacy law, be it the US related laws or Europe related laws or Singapore or Malaysia or Australia or any such even Indian law, you see a common thread, a common set of pillars, a common unity across the diversity in all these laws. So there are 3 major parts, 3 major diversity aspects where you see unity that I'm going to present to you. One is notice. So notice, has anyone raised their hand? If it's by mistake, it's okay. But if you have a question, please put it in chat as well. Thank you. Yeah. So notice, what is notice? Notice here is simply, think of your, going back to your school days, you have a notice board, right? So where important announcements are kept, right? Sort of in a very similar way, how your data is going to be processed, right? Now making it known to people. I'm sorry, please excuse me for a minute. There's someone at the door. Yeah, sorry about that. Yeah, so notice, if we talk about notice, it is simply think of that news bulletin itself. What do you put in news bulletin? Or how do you put it, or what do you expect? A student reading a notice, you expect them to understand it easily, right? Not too complicated. So that is simply what they are also saying, right? Let's say you are a Tamil medium school, you will not put a notice in English. you'll mostly put it in Tamil, right? So that is a way to visualize what notice is here also. Is plain and clear language. In the sense, don't use jargons, don't use, you don't need to show that you are very eloquent, or don't use generative AI and all these big keywords to generate your notice. Make it very simple for people to understand. Make itemized, that's very interesting, something that I have actually italicized on my slide. Here, I refer to the specifics, the uniqueness in Indian law. The other ones are still the same, but here there are slightly differences that this italicized text refers to specifics in the Indian law that are different from the other laws, right? So they call for an itemized, they use the word itemized. What is itemized? Go back to your billing, right? So if you go to a shop, if they print huge bills for you, receipts, right? So has what is the product name, what is the quantity, what is the rate, what is the discount, what is the price for all that, right? So that is an itemized bill that you get. Even the telephone bills that you get are itemized bills, for example, right? So similarly, your notice should be itemized. Itemized in the sense, be specific, be clear, this is the purpose, this is what I need, this is the case that your data is going to be processed. So that is called itemized, right? So being very specific, don't put huge things in a big paragraph, rather make it very simple, bullet points, specific, neat, intelligible. It can be part of an existing document in the sense you are, let's say for example, you are signing up for a bank account, that as part of your other documents that they give as part of the brochures, this is another important thing. So you don't have to give your privacy notice specifically. You don't have to put it, print it separately, or such as hand it separately in your hand and the other envelope in your separate hand. You don't have to go into such kind of difficult manners. The law has been very clear here, saying that you can add it as part of your existing documents, such as if you have a welcome kit, such as if you have an account opening kit or something like that. That part itself, as part of your existing brochures, you can actually include the notice. Notice again, what should be there in the notice? The law again has specifics, but there's a commonality across all the laws also, like what data you are collecting, why you are collecting, those kind of generalized things on really what you are going to do with the data, right? So that being clear about that is what generally notice means. They have maintained the same tone here, but they have gone into one specific and said it should be itemized, and it can be part of a existing document or a separate document. And this is a different specific thing for India, given that we have these different languages, regional languages, and all of these very specifics. They say that 8 scheduled languages, notices in those languages should also be given, such as if you are doing a business in, say, in Delhi, most likely be putting it in Hindi. If you put it in somewhere in Tamil Nadu, you'll most likely be doing it in Tamil. So what are the 8 scheduled languages? That's a huge list. I think 14 to approximately 22 are almost there. I'm very bad with my civics, so there is a difference there. So there are at least 14 languages in which you should do it, depending on which part you are actually, which state you are targeting, which sort of demography the people are from. You should put your notice in those languages, right? So what do we do for existing data is, for example, the law is coming up next year, right? So it's coming to enforce next year. What do you do for the data you collected in the past? You have to give the notice as soon as reasonable is what the law says. For example, the next time you meet that person, the next time you have a conversation with them, the next time you reach out to them, right? So that is the most reasonably practical manner that the law actually prescribes. Yeah. So the next part is consent. Oh, okay. Yeah. So consent is one way that I remember how consent should be. Right? We have heard about consent so many cases, in good or bad cases. We've heard about what consent is. Even again, every other regulation around the world, at least contrasting with Europe GDPR, you find those 4 keywords, right? Which I put it as SIFU, SIFU for my memory. You can, however you want, you can shift it. Why have I put it SIFU is because SIF in Hindi means only you, like you are the party of that. So that's one way I could remember that. What is SIFU is specific, informed, freely given, unambiguous, right? So those are the 4 keywords that you should remember about consent. It should be specific, itemized, if you can think about that. It should be very specific. It should be informed. In the sense, you should not assume that you are informed. you should make it clear that that person is aware of the risk, like how they say for these advertisements for mutual funds. Mutual funds are subject to market risk. Please read the document carefully before investing, right? So they give you information. They are keeping you informed. Like, hey, buddy, you better be careful. This can get a bit tricky, or this is how your information is going to be used. Right? That is called information. They should be informed of how their data is being handled. It should be freely given. Freely given in the sense you cannot pre-tick a box. We already know how consent works. Don't tick boxes. Don't take implied consent where it is not possible. We'll go into that later. But it should be freely given. An actual valid consent by law should be freely given. In the sense, you as a person use your volition, you use your decision-making skills, you use your brain and say, yes, I want to do this. With all my heart, I am saying yes. Right? That is what is freely given is. If I am forced to give, then it is not really consent. Right? So, for example, in an employer-employee relationship, that is where often we find that consent is not the right basis, because you need your job, right? So if they say I'm going to sell your data, you consent, you have to put a tick, right? For the most part, you are forced. Or if you look at your payrolls, right? If you want to make payroll payments for your employees, you cannot sit and get their consent. If they don't give the data, you cannot process payroll, right? So there is no freely given consent there. They have to give that data, right? So that is called does not constitute freely given. And unambiguous indication of wishes. What is unambiguous? In the sense, again, that's a separate whole topic, maybe some other day. What is dark patterns? How to understand dark patterns in consent? We'll look into that some other day. But unambiguous in the sense, no reason of doubt, no cloud of doubt. I'm very sure this company is going to process my data in such a manner. I'm very much informed and I'm freely giving my consent. I'm saying I'm clicking on a tick box or I'm clicking on a button affirmatively and I'm saying okay. It is not like just because I am visiting your website, you are free to do anything with my data, right? You cannot take that. For example, the most places where this is misused is this cookie consent. If you actually see some websites, they say that by scrolling on this website, we assume that you are given consent, or it indicates that you are given consent. Whether that is true, whether that is right, whether that is wrong, it's a separate debate. But most likely, you can assume that it's not the right way to get consent, right? It should be unambiguous in the sense, you cannot assume that that person has assumed. You cannot think that that person probably in all their capacity and knowledge are actually doing that, right? So it should be unambiguous. Karthik, you raised your hand.
Yeah, and maybe you can also throw some light in terms of consent from a financial sector point of view, right? Where people give a consent that or some apps in the mobile world today, which ask us whether can we allow them to track activities from the other website, which also contains your personal data and also PI as well. So maybe can you throw some light, how does that bill will put some more restriction on these companies to put some restriction on how they can use the data, because it does go to third parties and other stuff as well.
Yeah. So let me just show you I have a screen to show. I'll explain with this, for example. So this is one example of how consent can be misused by any party. Even the current, we have a lot of evidences in India itself of how they misuse consent to be. So if you see the difference here, I've taken this from the ICO's website. So there are stark differences the way that you visually perceive this itself. I mean, the data collection part, the fields are almost the same. But if you look at the bottom portion where they've given this legal declaration or this left-hand side image that you actually see, you see very specific that how your information will be used and how you would like to be contacted. So that is how specific and fine-grained consent has to be. So if someone is misusing that, such as hiding it into large text, or they make an assumption that just by giving your data, you consent to all of this, right? That is called as an umbrella consent. Umbrella consent does not work. Consent has to be specific. So similarly, you are saying, yes, I want to do this, right? So if you see a stark difference between how this is actually put in practice, this is an example that you can think of. Similarly, for financial companies that are already regulated, already part of a regulated industry, how does this come into practice is you cannot hide your disclosures to third parties. You cannot hide your secondary purposes, such as collecting data for one purpose, but using the data for another purpose, right? I cannot simply say by creating an account with us, you authorize us to, use your data for anything that we wish to, or in any manner that my company thinks is good, right? So you cannot give an umbrella consent. You cannot hide consent or language or clarity into huge lines of text. So given that, this data selling is still an activity that is actively happening, or data, when you look into data in order to promote loans, I came across a situation where one of our integration partners wanted to have some insight about how a particular integration is being used, so that they can promote a type of loans to those users of our services. Very obviously, their use case was very simple, straightforward. Very probably could think of it as very what a wise way to do it, what a nice way to do it. But if you look at it from the privacy lens, that's called as a secondary purpose. They have hidden that knowledge or that information in one of that integration agreements somewhere deep down, which has been failed to be reviewed, right? So that is one portion that you should always be careful about when it comes to reviewing the parties with whom you have you sign up for, such as either in your business or for a service or for any of that matter. Very specific, it should be informed and should be freely given. So I mean, it comes into practice depending on different situations. So for example, marketing is going to be a different story. If it's going to be a service, it's a different story. Healthcare, you know how consent actually works. You have to go into an operation theater, someone has to give consent. You are not freely given consent there. You have to save that person's life, right? So in different spheres, in different domains, consent has been misused, but this law would most likely, and I'm optimistic that it will regulate that to a greater extent. And I feel that the regulators will take consent as one of the most scrutinized areas as well going forward. Yeah. So just going back to this, okay, I'll just take that question that came up regarding some Sakti data fiduciary or in any language specified. Yes. So is it any language? Not necessarily the Tamil. Yes, definitely. That's what I said. We have to look into the eighth schedule of our Constitution of India. They have listed down languages, right? So whatever languages there it is, depending on who you are giving that service to, which location they are availing the service from. If they come under the one of those languages under the schedule, you should give it to them, not just like for example, if Tamil is part of that 8th schedule language, then Tamil you should make the disclosure, the notice in Tamil. If Hindi, obviously Hindi will be part of that, so you should have to make the disclosure in Hindi, not just in English. So we have to look into that 8th schedule languages in the Constitution, and accordingly, depending on our targeted demography, we should make that translation. Right. So a few more points about consent is it should be easy to give and take. So as easy as this is very similar to GDPR. So not more talking more on that. Flow it down to your third parties. Like for example, if you got data from a person for a particular purpose based on their consent, now you are giving the data to someone else for a given purpose, such as a shipping provider, this Amazon, for example. They have to ship that product to you, right? But if you remove your consent, they cannot ship that product back to you. So consent is not a lawful basis there. So flowing down of consent means if a person has revoked their consent or withdrawn their consent for you to process the data, if you in turn have disclosed the data to someone else, then you should let that other party also know that, hey, this person has withdrawn their consent. You should stop processing that data ideally. So, right. So that is called as a flow down. And you should have a record of consent, basically what, when and date and time when that consent was given. So having records of that is important. And your consent manager is a new concept given under the DPDP. What is a consent manager? It's most likely another body or another institution or organization who can take up the cost upon themselves to facilitate the rights or to manage consent of a person, right? So it could be most likely an institution, or it's actually a business opportunity for many companies also, where they can act as a consent manager. There are specific requirements. they say you have to register yourself with the board and all of that. Let's wait and see how it actually pans out. But consent manager is simply a mediator for managing consent of different data principles, right? So you can, instead of directly talking to a data fiduciary or revoking your consent directly from them, you can do it through the consent manager, right? So consent manager is going to be most likely a company, a set of companies that have a platform or an application or a particular set of forms, where you can manage your consent, right? So that's going to be a consent manager. Okay. Yes, data being stored outside and the responsibility. Yes, Shekhar, I will come to that. Okay, we already saw what an example of what consent is. This is how a notice is. You can see how easy and interesting it is to read. This is taken from a company called Zoho. A very interesting notice that they have actually given is data you give, data we collect. They made it very interactive. They made it very easy to understand. So now what data we collect. So if you actually look at these two images, one is data that you give, data we collect. Data we collect is simply it could be automated means, or it could be direct, whatever the case is, right? So one is you give it on your own accord for a sake of processing, or the company collects it on their own because they have to provide that service, such as your IP address or all of that is data that they collect, right? An extension of that is this. So what is good about this notice, if you actually see, they have used icons, they have made it very simple to read, and they have given a read more at the bottom, right? So if you just look at it, you can see what data they collect and what purposes they collect it for. And if you click on read more, it opens up a bigger passage where you can read in detail how the data has been collected. So practically going to notice, right? One of the requirement was plain and clear and simple. So this is an example of how you can see it in practice. So we saw this. Okay, the next is general obligations. Okay. So general obligations that you can see is as a fiduciary, what are your general obligations? Nothing very unique to the law per se, at least in terms of general obligation, except for they specifically mentioned grievance redressal. Most of it is pretty much the same that you find across other geographies also. So that is basically accuracy and completeness of data, taking the right technical and organizational measures. I'll explain that the next slide. Security of the data, incident management, records management, how do you maintain and process records, publishing contact information of the privacy officer or something like that, whoever is in charge of privacy of that particular data fiduciary, and valid contracts with all of your providers, such as your data processors. So this is going to be a general obligation on all data fiduciaries, whatever space you're in, whichever domain you are from. These are going to be very common across all, and it is common across other legislations also. So if you're already doing it well, such as in your European operations, most likely just implement it here. It's pretty much the same game. So the specific point is grievance redressal. I'm sure you already know about the social intermediary and those legislations that actually came a couple of years ago, where grievance redressal has become an important point in India. They have asked companies to, the law has actually asked companies to put up contact information of grievance redressal officers, so that if they have any grievance regarding any company, that information should be published. So that carries on to this DPDP as well. So just trying to understand obligations, what I just highlighted the three major parts. One is technical organizational measures, records, and incident management, right? So there are, again, too much to discuss, but I don't want to go into detail. But what do technical and organizational measures actually entitle? I've just taken an example from InForTrend, who have nicely written their technical and organizational measures. So what does it entail? What does it include? What is technical and organizational? I'm sure as auditors you already know about that. Is any physical control, technical control, organizational or administrative control, right? The same thing is what they are mentioning here. So physical access control, data access control, such as firewall deployment, antivirus, permissions management, visitor management, data usage controls, user roles, administration of rights, shredding, secure storage, separation control, logical separation, physical separation, all of that comes. Integrity control, transfers of data between different devices, different mediums. Input control, you already know about, traceability of the law, traceability of the data across the processing integrities. clear responsibility for deletions, availability and resilience, backups, RAID storage, removing unnecessary ports, virus scanners, software updates, backups, all of that comes under your availability and resilience. Procedures for this is the organizational control, like review, policy, administration, training, audits, right? All of that comes under your administrative controls, which is your organizational control. So this is an example of what organizational and technical controls actually mean, right? So depending on different organizations, the level of implementation will obviously be different given their risk scenarios, given the type of data they process, given the type of personal data, and in what context they are processing it. Accordingly, we have to put the right measures. Not taking into GDPR calls it as a statement called as taking into account the nature, severity, and risks and harms to a person, and the risks around processing the data. Take the necessary steps is what GDPR says. In a very similar way, it applies here as well. Take the right measure. You don't have to go over and above what you'll never put a safeguard for a very lightweight data, a very cheap data, right? For something that is not valuable, you will not store it in a locker. The very similar concept applies. Taking a risk-based approach for technical organizational measures for protecting personal data is the concept here. Records management, that's a separate domain itself, but data inventory, have a record of the data, classify the data, have your retention and disposal schedules. Like, you don't retain data permanently. That is what it actually entails. Keeping data only for a restricted purpose, for restricted time is what it calls for. And the verification sign off, you already know the NIST frameworks for data shredding, data disposal, degassing, and all of that. All of your data management, the records management comes under records managing. And incidents is no company is safe and secure at all times. Right? There will be incidents in some severity or the other. Depending on that, we are prepared. So using or utilizing your existing incident management frameworks itself for privacy management is quite sufficient, because as of date, the law does not clarify how quickly you're supposed to inform the affected people, how quickly you're supposed to inform the board, the data protection board, who's the regulator in that case. The law is not very specific as of date. It may change. The government may come up with advisories on that, but as of date, there is there's not much clarity there. So being a resilient organization, being prepared for the worst, right? So having our incident management processes, such as your all through the different phases, the stages, such as your detection, your containment, eradication, recovery, and your post-event activities. Considering all of that is core, because if you actually see this particular slide, this obligation all talks about security and protection, data protection, right? So this particular matter of protection of data, the security and the data protection aspects carry one of the highest levels of penalty. 250 crores is the penalty that has to be paid. But again, whether it will be imposed in the first instance itself, probably not. It depends on what measures you've already taken to protect. Despite all measures you've taken, if the data has been breached, right, you will not be levied the 250 crore penalty. It will obviously change. Let's go into that later, how they actually calculate the fines, what are the factors they consider. But this is a very core aspect of the law, is data protection. Similar to how they talk about rights, privacy has to do with rights. Similarly, data has to do with protection. So how do you protect the data is through these different obligations that you can have. Is consent the only lawful basis? We have been speaking about consent so far, right? So I need express consent. I need that to be specific, informed, freely given. Is consent the only way to go forward? Well, good news is that no, you have something called as deemed consent. The term deemed consent has been removed from the latest version of the Act, but in previous versions it was there. But in the latest version of the Act that has been published, they use the keyword legitimate use, right? So legitimate use, they've actually qualified and given some examples. I won't call it examples, factors or situations where you can, don't have to rely on consent. Rather, you can process the data if that particular activity falls under any one of these mentioned use cases or scenarios, right? So what are those? If it is voluntarily given, if someone comes to you and, like, such as you are meeting a person at an event, in a corporate event, let's say you are having a booth at a conference, right? So you have a fish bowl or you have a farm, that someone comes and types in their data on their own accord, right? It is a voluntary disclosure. It's a voluntary, they give their data on their own accord, on their own volition, right? That's called voluntary. And you process data in a reasonably expected manner, such as if you give your visiting card, your business card to someone, you reasonably expect that they will call you or text you, right? So that is a reasonable expectation. So that is permitted under the law, where you don't need to get their consent saying, I am going to contact you for this and this purpose, or give a notice. You don't have to worry about that. If they give it voluntarily on their own accord, you can process the data. That is one of the legitimate use. Similarly, legal requirements such as your tax records has to be retained for 8 years, right? I cannot get, as an employer, I cannot get my employees' consent to store tax records for 8 years, because there's an overarching legal regulation there. Similarly, the medical space or the financial space or the telecom space, you have a lot of existing regulations. SEBI regulations are there, IRDA regulations are there, TRAI regulations are there. You are already having a lot of regulations which involves you to retain data for a longer period of time. Only that data, if you have such legal requirement, you don't have to delete the data very soon or when someone asks you. Like, just because you're quitting a company, that company is not going to delete all of your data, right? So they're going to keep some data for at least 1 year, some specific data for 3 years, some data for 8 years, some data for 10 years, right? So that's where your records management actually helps, right? So that data classification, you know what data you have, and you have a retention schedule for them. As part of your retention schedule and your disposal schedule, you'll be considering your existing legal requirements. So if you have a legal requirement to collect data, such as for KYC, it is regulated by RBI to have KYC form. So the bank cannot come and say, give your consent for me to collect the data, because there is a legal requirement to collect KYC information. So that is an example of legal requirement. Medical emergencies, as we know, we cannot wake up a person who's affected in an accident or in COVID and ask their consent. That is not practically possible. So they give an exception saying you don't have to worry about consent there. If it's a legal or if it's a medical requirement, a medical emergency, you can disclose data. You can process data in that particular occasion. Employment purposes, again, in this version of this act, they have actually diluted employment purposes, but not to worry, but they have given some provisions around that. And if you have to, for protecting your company's intellectual property or confidentiality of those documents, if you have to process a person's identity, which is like how your SOC team does, right? Which includes this other point also, network and security, to protect your service, to protect your website, to protect the application, you will be collecting some information like this. For example, IP address. IP address is now understood to be personal data under the DPDP. So whether you can collect it, whether you need consent, no, you don't have to worry about consent there, because if you do it for network maintenance, such as your load balancing, session stickiness, all of those sort of network oriented things, or your security oriented things like cross-site request forgery, your SSRF, and all of those kind of reasons, to protect your site, to protect your business as an employer or as a service provider, whatever the case is, you don't have to worry about collecting that specific data based on consent. Doesn't mean that you can use someone's blood group, doesn't mean you can use someone's salary information under any of these ambits, right? So you cannot collect someone's blood group saying I'm protecting my website by using someone's blood group. That does not work. So that is where reasonable expectation, and that is where privacy matters in context. Privacy is generally not an absolute right? Privacy varies across persons. If you're sitting in a room or sitting in your cabin and you have a CCTV inside your office, you have a reasonable expectation of privacy. I mean, you can understand that, for the safety of the other employees, they have kept a camera there. But if you keep a camera inside near a washroom or in a private area, that is wrong, right? So that is a reasonable expectation of privacy there. You're expecting to be protected from surveillance or any such kind of intrusion in your house. You have a reasonable expectation of privacy. You don't expect the police to walk into your house without a warrant, right? That's a reasonable expectation. So privacy is always looked into in context. So if someone asks you, this is how this company is doing, or this is how privacy is here, and here it is different. Why? Because privacy differs in context. That is where expertise, legal interpretation, all of that actually comes in. In every situation, like how you do your risk-based approach for protecting data. Similarly, in context also, privacy is taken to be in a risk-based approach. That's where we call as risk of harms. What is the harm? Like, for example, harassment is harm, blackmailing is a harm, mental torture is a harm. There are so many harms for a person, right? So that is where privacy actually comes into context. Similarly, if a data is publicly available, don't have to worry about consent. Like, for example, my LinkedIn profile is already publicly available. You can use it without my consent, right? So that is publicly available information. And they've also given one more case is fair and reasonable purpose. There, again, lot of examples there, but consider again the case of marketing, whether you need consent or not. Probably if it is fair and reasonable, if someone is already your customer and you want to invite them for a conference, or you want to send them an email or an SMS regarding an interesting feature in your product or in your service, if it is fair in the sense, that person is can understand that, given this relationship between a customer and an organization or a business, this communication would happen, right? It is fair. It is not illegal. It is not unethical, right? So that is fair. That is what fairness means. And it is reasonable, right? So that is where you have the legitimate interest coming in and the reasonable expectation of the person. So whether consent is the only lawful basis, lawful means of processing data, no, you can rely on these other things. Again, privacy matters in context. Always remember that privacy is not the same everywhere. Just like you have a risk-based approach for your auditing, consider the high-risk areas first. That's what they say. Similarly, for privacy, you consider risk of harm. What is the harm to that person given this particular processing? Given using the data in such a context, such as AI for seeing a person's face, such as in the Zoom meeting, if they are seeing how my mood is, if Zoom is actually taking my video recording and using it to improve their model, that is not my expectation. I am not reasonably expecting that. If IIA actually does that, probably I'm expecting that. But if Zoom as a provider does that, I'm probably not expecting that, right? So that is where privacy matters in context. Rights, you have 4 major rights that are given. If there's any questions though, you can also post. I'll take time to answer those. Just a few more slides. I'll quickly complete with that, just to give you a review about the law as well and some examples later on. So right to information is very similar to how we already have, but little more better, I feel, is you can ask a data fiduciary whether they have your data, a summary of what data they have about you and to which parties they have disclosed your data. Now you have that right as a person within the territory of India. You have the right to ask a fiduciary whether they have your data on some matters. If you potentially feel that they have your data some way or it is leaked in some fashion and you want to confirm whether a given company or a given institution has your data, you have the right to do that. And they are supposed to give you in a certain format, which will again the central government would give through some rules or notification on how to actually do that. Right, that's called the RTI. RTCE is your right to correction and erasure, similar to how it is in GDPR. You have the right for inaccurate information to be corrected. You have the right for the data to be erased, similar to your right to be forgotten. You have the right to erase your data. But again, that is where it differs between an employer context. For example, they will not erase your data as soon as you exit the company. So it is not an absolute right. For example, these insurance companies or these loan companies where you don't have an account, but they have obtained your information somewhere, you now have a right to ask them to erase your information. That is something good for all of us as people of India. Right? The next is the right to grievance redressal. As I already mentioned, one of the obligations of a data fiduciary is to have a process for grievance redressal. So that a data principal has the right to get their grievances resolved through contacting whoever has been listed in your company as a grievance redressal officer or something in a similar capacity. If you don't get their response in 7 days, most likely 7 working days, you have the ability, you have the right to complain to the Data Protection Board. The Data Protection Board is the authority that is being created under the law to take care of all of the data, to ensure that the law is being adhered to, like how we have the IT income tax offices to take care of all of our taxes, like how we have the Niti Aayog for taking care of evolvement or improvement of the country. how we have different ministries, right? So this would probably come under the MeitY ministry or the telecom ministry, somewhere under them, where that board will be established, where you can write to them and say this particular data fiduciary is not responding to my request of grievances. They are not, responding to me. They are not handling my right. They are not, taking this action seriously. You can actually complain. So that is good. Like how you can complain to the TRAI if a particular telecom operator is misusing your data or not giving you what you are due under your consumer laws. Similarly, you can notify, you can complain to the board. This is a different one. The next is the different one that I mentioned, right to nominate. So either in your death or in your incapacity, you can actually nominate another person to take care of your rights, such as your right to information or correction or erasure. Let's say after your death, you want erasure of your information from certain companies, and assume that those companies no longer have a legal need or a business need to retain your data. That person whom you nominate can actually raise that request to that fiduciary and ask them to correct their data or update their records or erase their records according to however you do. That's the right to nominate. Okay, there's a question. I'll take it from the chat. Does deletion of data include deleting from backups also? Definitely, it involves, because data deletion is an entire suite. You have to consider all your infrastructure when you delete. So if you have it on paper, if you have a printed version of a digital copy, right? So the source is still digital, but you made it into a printed version. So most likely you're supposed to delete this data also. But again, this is a little gray area that will only time can tell. As case laws come, we'll understand how it is. But most likely, I feel that if you've taken a printed version of a digital copy, such as an Excel sheet of all of your customer list, you downloaded it, you printed it, most likely this printed version will also come under that ambit, is what I feel. Right? This is just my opinion, not a legal opinion. So similarly, your backups are still digital mediums. Your backups, even if you store it as printed versions, again, since the source of data is digital, it will also come under this ambit, right? So yes, you should consider backups also. So this is about children's data. I'll just touch upon these key 3 points here. Is children's data should not be processed without their consent, so-called parental consent here, right? And you should not do any tracking or behavioral monitoring of children. The law has a very ambiguous term about detrimental effect to a child. So what is a detrimental effect to a child? It's up to the lawyers to interpret, right? Detrimental effect is anything that can cause a legal effect to a child, such as some incident that can cause a lot of trauma to them in their later years. It's a detrimental effect to them, right? So any processing of data, if you go back to the Nazi period, right? So the their personal data was used to track them down to shoot these Jewish Christians, right? So that was a history of why European law also became very strong. Similar way, children, you already know that children's rights are protected a lot under law, right? So all this child trafficking, the children pornography is already being monitored effectively. So if you use a child's personal data, for example, their photo or their video, or you morph it, or you track a child, right? So all of that is going to come under the ambit of the law, which is good news, even better, more security, more privacy for our children. So if a school is going to use a person's, your kid's information, most likely it will be under parental consent, right? Without parental consent, they cannot do it. Again, if they don't have a parent, they can go under a legal guardian, right? That's already provided under law. Very similar to how GDPR, even US laws are. Parental consent is an important facet of processing children's data. So age given here is 18 years, like how typical it is in India. You're considered a minor under 18. After 18, you're a major, right? So very similar logic has been applied here as well. Okay, there's a chat and a question. Children data, like it's taken from any NGO, or we are dealing with such org, then from whom to take the consent will be required, as it is already from some NGO. Okay, so the concept here of you have obtained data from an NGO, right? The NGO would have taken the parental consent probably, but it depends. That's where you come under reasonable expectation, right? So here again, whether we have to get consent, parental consent, or whether you can go into any of the other ambits of the law under a lawful basis. It depends upon what purpose you are collecting the data for. For example, if you are collecting the data in order to save a child who has been trafficked, right? Most likely you will not be requiring parental consent there, right? So the purpose for which you collect the data from them is going to play a pivotal role. For example, you were collecting their information for selling some books, right? Or if it's let's say an academic platform is collecting data from NGOs for selling their product, it most likely needs parental consent. How directly parental consent or whether NGOs parental consent, that is where, if you remember the consent slide, we spoke about flow down of consent, right? So ideally, the NGO would have or should have collected the parental consent. They can actually flow it down to your organization who's using the data, as long as that reasonable expectation of that parent is there. Like, okay, I'm giving it to an NGO, another company or another organization may use it for a very similar use case, right? Most likely you need not worry about consent. But if you're using it for a different purpose, right? You're trying to sell a different product, or you're targeting children for a different interesting new initiative that you're taking, most likely you have to get separate consent by giving notice to the parents. Then NGO would most likely have to give notice to the parents saying that they are disclosing their children's data to another company, and they have to get the consent specifically for that disclosure, right? So again, why I'm not able to exactly give you an answer is because it depends again the context and the purpose for which you're collecting the data. Okay, in case of orphans, yeah, if an organization dealing with orphans, okay, Ananya, I think I'm not able to fully understand your question. So I think as much as I can understand, you're saying that it is taken from an NGO and it is used to deal with orphans. Okay, probably if you can unmute yourself, or if you would like to speak your question, I can answer it better, because I'm just having a little lack of clarity in your question. So I would appreciate if you could actually speak up. Probably you don't have the option to speak.
Yes, sir. If they raise a hand, I can allow them to speak. Yeah.
Yeah, Ananya, if you'd like to speak, please just raise your hand. We'll give you the permission. Yeah.
Yeah, allowed.
Yes, Ananya, please go ahead.
Yeah, hi. Am I audible?
Yes, yes.
Yeah, so I just wanted to know, in case of the organizations which are dealing with the orphans, so concerns need to take from whom? I mean, in case of NGOs also indirectly parental concerns, fine. But suppose our CSR team is working with some organization who are dealing with the orphans. Say we are teaching them, or we are doing some academic kind of things, this kind of services, but CSR kind of activities. So does this comes under this law? I mean, we need to take consent then from whom? Because we don't have any parents.
Definitely. That's where the legal guardianship comes. Who's the legal guardian for these orphans? It's going to be that NGO, right? So from that NGO is where you'll be, or if they are the legal guardian, you know how a legal guardianship works, right? So that being the case, that NGO would be authorizing you or giving the consent for using that children's data. You should obviously ask. Again, it depends on why you want to use that information. If you're going to, let's say, publish a case study or put a reel in your social media involving footages of children or something like that, obviously you'll be asking that NGO's permission. You cannot be asking a child's permission in that case. So legal guardianship and what you do with the data is going to play a very pivotal role in doing that. And yes, Karthik.
Yeah. So, Andrew, maybe we can finish off the slide and then we can take up, there are quite a lot of Q&A questions have come out. Maybe we can do all that in the end. Maybe we can finish the slides because we have 20 minutes more to go, and then we can take it up. Yeah.
Okay. Yeah. So yes, just summarizing Ananya's question is, if you if a child does not have parents, your legal guardian should be giving the consent. Again, the consent should be the same specifications of consent would be there. So be clear about what purpose you are getting that children's information, whether you're taking their pictures, whether you're reporting it on social media. All of the purposes should be explicitly made available to the legal guardian, the legal guardian should take the step to give consent in that case if they do not have parents in case of orphans. So how do we actually get parental consent? This is a reference from the US. The US laws have actually given, the FTC, which is the Federal Trade Commission, has given some examples of how to get a parental consent, parental or legal guardian consent, right? There are 4 or 5 methods that you see on screen. I would like to discuss that, but due to short time, I cannot go in detail, but just an idea is, for example, how in the same NGO case itself, I'm just quoting it as an example. So you would write to that NGO mentioning why you want to use the children's data on a paper or in a printed format. You get their consent on paper and you digitize that, right? So because again, it depends on what data you're going to use, whether you're using the photographs of the children or the names of children or whatever factors or whatever attributes of the children you're taking into account. So you can ask them to fax that consent to you. That is one method. The legal guardian can do it, or over an email. That is obviously another method. Or if it involves a financial transaction, such as these apps, these games for children, these applications for children, YouTube Kids with a payment, or Spotify for kids with a payment, or these games applications, right? A credit card, a debit card, all of that has to be verified. But in practice, we've also seen case studies where children, children's fingerprint has been added or their face ID has been added to the device already by the parents. So you go and make a payment, automatically it gets debited from the account, and you already see news of how many losses have been, parents have been complaining of losses as well. So many lakhs of rupees has been spent by one child, I think in China, I believe. So that's a practical problem that we have. But if it involves a financial transaction, the FTC recommends a way of getting the notification to the primary account holder, such as obviously the parent or the legal guardian, saying this amount has been credited. That is one way they can actually try to verify consent, parent consent, or ask the legal guardian or the parent to call a telephone number and prove that that goes along with the 5th point is knowledge-based challenge questions. Answers that only a legal guardian or a parent can give. A child cannot think that level and answer that question. Knowledge-based. Like for example, if you run a school, you would know some information that only the parents can actually give. The child cannot give that information, right? So those kind of questions. Those are some practical ways of getting parental consent. Just running through the slides with lack of time. So data transfers, one of them had already asked that in the Q&A. So I'll just answer it as part of the question also. So how does data transfer happens? The law is very clear. Actually, it has evolved from the previous bill. Currently, it is in a blacklist model. Blacklist model, initially it was in the whitelist model. Like Europe is a whitelist model, like how you do in your firewalls or in your routers where you have a whitelist and a blacklist. Similar cases here. In a case, don't go technically here, but it's just a model. Right, so the list of countries to which data can be transferred to, like without any worry, is called as a whitelist. They're giving you a list of countries already. That is what the first versions of the bill actually had. They said that the list of countries will be given, only to these countries you can share. They also had a data localization requirement, but over time that has changed. The current act is in a blacklist model where the government will later notify through any regulation or any rules, saying that these countries you are not supposed to transfer data to. Again, how will they do it? What factors they'll take into account? Friendly relationship with those countries, existing commerce, trade, all of those factors, political factors, geopolitical factors will be taken into account to tell which countries you are not supposed to transfer data. Talking about data localization, right now there is no need under the law for data localization. Initially there was, but now the latest act, one has been published, you don't have to worry about data localization. But here's the caveat, the catch is that if there is an overarching regulation, such as a financial regulation to store data locally, a copy of the data that still is, that takes the higher precedence. So you cannot overrule an existing RBI circular, you cannot override an existing IRDA circular where it requires data, local data localization or data embassy or whatever you call it. You cannot override that. That will still prevail. Right? So this is for any other data that is not already regulated by these regulations. So what are the risks to privacy? Now we'll be talking about the law, the concepts about the law, a little more technology, a technical way. If you look into it, what are the risks to privacy? The source of this I actually forgot, so I'm sorry about that. But this was a very interesting slide I saw in a particular session, right? So in different stages of data processing, this is called as the life cycle of data, right? So data life cycle has different stages: collection, usage, storage, disposal, transfer, and deletion, and all of that, right? So in all of those cases, you have a lot of risks to privacy. That we've been talking about technical risks, we've been talking about organizational risks, technical measures, organizational measures. We've been talking about data protection, we've been talking about rights. So considering all of that, putting all of that in a box, if you split it up into risk-based approach again, you see that it broadly summarizes into 4 or 5 major categories, like unsecure collection, misleading purpose, tracking of usage, indiscreet or covert collection of data, no proper consent. All of that comes under collection. Under usage, you're selling data, negligent handling of data, or you're subject to a phishing attack and the data is now going somewhere else. You are using, but you're now going somewhere else without your approval. Under storage, under retention, you're having a lost device, compromised device, malware, ransomware. All of that are some risks that you see, where not just your intellectual property protected data or your CIA protected data, but now also privacy or personal data is also now to be considered specifically because of the DPDP, right? So you have to give sufficient attention to personal data protection also, as much as you see the overall facets, overall assets of your company in terms of confidentiality or integrity. You should now worry about or think about these aspects of protecting of personal data in the different life cycle of the data. Like putting it a little more into context, talking about all this notice, consent, legitimacy, necessity, proportionality, all of that we saw, how does it fit into the life cycle, right? This is an interesting slide. So in collection stage, that's where the consent, notice, legitimate uses, the necessity, all of that comes. Someone was saying that the law is not actually very clear about necessity. For example, GDPR is very specific on necessity and proportionality. Like you should collect data only for that necessary purpose. You should not, which is similar to that umbrella consent that I mentioned. Don't collect too much of data, right? So collect it only for that purpose and use it only for that purpose. And it should necessitate that processing. For example, for attendance tracking, is biometric clearly necessary? That is a question that I would argue, right? You can still go with some other way of doing it. Whether exact GPS location is required for checking in your attendance, that's a question. Is it really necessary, right? So you should consider necessity. The law actually has that in one of the sections. It is in written, in line. It is within the law itself. It is not specifically as a title, but you would find it in the spirit of the law, even on the letter of the law. So during collection, these are some facets that we should look into. During usage, reasonable use, lawful use, think about the rights of people in that use. You should use only accurate and complete data. Don't use old data, right? So obsolete data is always dangerous to be used. You should not be calling someone when they have changed their phone number. You should not call their old phone number. You should not be sending SMS alerts to their previous phone number which they have changed. If they exercise their rights to correction, you should ensure that it is propagated across all of your systems. Even if they have not exercised their right, it is an obligation of the data fiduciary to maintain accurate and up-to-date records. That is a common principle you follow across every other legislation also. That is where this fits in the information landscape. Storage, security of the data, like I said, is one of the very important aspects, and it carries one of the highest level of fines and penalties. So keeping data accurate, up-to-date, storing it safely with all your technical organizational measures and your record management program is very important. Transfer and disclosure, we already saw about countries which will be blacklisted soon. So that is something that we have to worry about when it comes to transfers. And rights in the sense, people should be knowing, if you remember the right to information, one particular point I mentioned was about data, confirmation of data and the parties to whom you have disclosed. So when you're transferring data to another party, you should have a record of that, because the person asks you whether you have the data. You should also give this information that I've given your data to X, Y, and Z party for such and such purposes. So having that record is also very important. Retention, don't simply retain data for a longer period, like already mentioned. You should have retention schedules, disposal schedules. Think of your existing legal obligations that you have. And where does it fit inside in deletion? This is the last stage, is deletion of, again, part of your records management program. People have the right to delete, erasure, right? So you cannot be blind about deletion as long as there is no legal obligation, as long as there is no need for the organization to retain data. You have to take into consideration their rights and also delete the data. Also, as a good practice, data retention and deletion schedule should always be there. Significant data fiduciary, not going to talk much about it, but as you know, that who is a data fiduciary? There's another term in the law called significant data fiduciary. This DPIA requirements, I'm not going to that now. DPIA requirements, mandatory to have a DPO, mandate independent data auditor. All of those requirements will apply to significant data fiduciary. Who is the significant data fiduciary? Is the government will again notify at later date. How? They will consider all these factors that you see on screen and say that, okay, this particular company or this particular class of, like for example, banks are significant data fiduciaries. Social media companies are significant data fiduciaries. Startups are not significant data fiduciaries, for example, right? So the government will soon come up with, again, a notification saying that certain classes or certain types of companies or organizations would come under the definition of significant data fiduciary. If your company comes under that class of significant data fiduciary, three major points is you should have DPIA, data protection impact assessments, again separate topic, right? You should have audits by an independent data auditor, again a very good opportunity for auditors, and they must have a DPO. Again, if you are a privacy professional in this space, at least for the next 5 to 10 years, right, in India, you have a good market of work. So what are the duties of data principles? The law, that's one thing I love about Indian law, is that they don't just simply talk about these data fiduciaries and data principles and rights and all. They talk about as a principle, as a data principle, you have some duties, like how you have the fundamental duties in the constitution, you have some duties under the DPDP also. So, okay, this is probably the wrong slide, right? Yeah. So you have some fundamental duties here, is there should not be false complaint. Don't make a fake complaint against any company. That is your duty. If you do, that company can sue you in a way. They can, every injunction can take about 10,000 rupees from you. If you make a false complaint and it has been tested in a legal way that it is false, right? You have the risk of losing 10,000 rupees as a person. I'm talking about data principle, not about a company. Don't fake or suppress your identity information. Basically, your identity theft, right? Your impersonation, misappropriation, that should be avoided. You should be your real self. Don't fake your identity. Provide only verifiable, authentic information when you exercise your right. Don't give any information that you think, for getting someone's right. You don't fake your identity. Don't give your own identity which cannot be verified. Such as, don't say I have this XUV 700 car, right? That is not verifiably authentic, right? So they need specific information about you to ensure that you are the person. That is where your security also comes in. So as a data fiduciary, there is a role here, which is called authentication and authorization. Your IIA would actually come here. You have to verify a person before giving their information. So authentication becomes a very important part. So how do you authenticate? As a data principle, you should give only verifiable data. Don't give data that is very old. Don't give data that is incorrect. Right? Give only verifiable data is what the law requires a person, a data principle, to actually do. What are the penalties? Like I mentioned, security violations can go up to 250 crores. Children's data processing and like violation of children's data processing or not notifying of a data breach can cost you up to 200 crores. If you look into converting that into millions, dollars or in European pounds, it's about 30 million US dollars or 27 million euros. GDPR has 20 million euros or 4%, right? So it's almost there. So the penalty is a huge amount. It can be an undue amount on small companies. So taking this very seriously is very, very vital and important. So how does the regulator levy the fines? If you see the slide, there are a few points that I mentioned, which is from the law. Nature of that event, gravity or seriousness of that event, how long has that breach been, what is the type of data that has been there, like whether it's a sensitive information, whether it is just contact information, or whether it is photographs, videos, depending on the type and nature of data, what measures you've already taken for protecting that, how effectively, how fast you're taking that's where incident management comes. If you're fast to resolve it, if you're able to mitigate it from further problems, your containment phase is very important. So having a strong records management and having a strong incident management becomes very critical. So if you have things in place that can justify to the regulator that, look, I've taken so much of steps, I've protected data with all of these, I have all processes, all of them have been reviewed periodically, all of them have been attested, all of them have been verified by external agencies, then the regulator, the fine that they levy on you will be less, right? So these are some factors that they will consider. These are some missing points that you can see in the law. Is the sensitive personal data. There is no specific definition of sensitive personal data, right? It is, but like I mentioned, the SPDA rules of 2011 would apply in that case anyway. But again, let's wait and see how it evolves. Automated decision making, such as AI-based decisions, fully AI-based without manual intervention. GDPR has that. Like you have a right not to be subject. For example, your loan is being rejected just based out of an AI tool. That now you, if you're an European, as in if you're coming under GDPR, if you have the right under GDPR, then you can ask the data controller to review that decision to give you a justification of why that loan was rejected. But in India, probably that is not something that we can do, because automated decision making, I'm not talking about automation, I'm not talking about automated processing, right? I'm talking about automated decisions that are done autonomously, more like robotic, more AI only, right? Without any manual intervention. We probably are missing that in India. Timeline from breach notification is not specifically mentioned. GDPR gives you that 72 hours and all of that. US has very specific state level breach notification laws, like 6 hours, 10 hours, 12 hours, 1 day for HIPAA. There are specific regulations in the US for breach notification. But in India, initially there was a time, I mean the JPC's Joint Parliamentary Committee's recommendation gave 72-hour timeline, but the latest act does not have that, right? So, but I believe or I feel that the certain regulation that is already there for notifying security events would kick in here, right? We have to wait and watch how they are actually mixing both of that here, right? But the law by itself does not give anything, but most likely the certain time period might kick in, is what I feel. Timeline for responding to those rights. GDPR has 30 days in certain cases. CCP has 45 days. Brazil has 15 days. India is not specific on the time. They just say that data fiduciary should respond to that. But if you are not responding to a grievance within 7 days, again, that's where they mentioned the date. They have mentioned 7 days. If a grievance is not redressed, then they can complain to the board, right? So that's where you can find a time. But right to correction, right to erasure, they have not specifically mentioned a timeline. There is no right to data portability, unfortunate, and no right to restriction of processing, which is there in GDPR. Right to data portable in the sense you can move your data, personal data, from one data fiduciary into another. That, like you already have these interoperability standards and all. SEBI is already coming up with some interoperability standards and all. That may not work for your personal data under this law. It may change again, but as of date, this is how it is. There is no factual intent on prevention of discrimination, such as discriminatory pricing, discrimination based on your gender, discrimination based on color, state you are from, all of that. In the US, the CPRA, they have mentioned specific problems, because in the US, you know the history, there has been a lot of discrimination, there has been a lot of past bad history for people based on discrimination, and there are many laws on that also, like Americans with Disabilities Act, Pregnancy Discrimination Act, and Equal Pay Wage Act. There are many acts in the US that are already there for preventing discrimination. Similarly, in India also we have some for regulated spaces, but this comprehensive data protection law that we're talking about does not have a specific mention. So most likely whatever is already there, such as this Gender Wage, Disparity Act, all of those acts, whatever is already there would still be in force. There is no specific mentions of record of processing. Article 30 of GDPR talks about record of processing. We don't have that as a specific mention. So, which is not a major problem, but it is a good accountability measure for organizations, which is actually missing here. In the GDPR, we talk about compensations, right? We have seen about penalty, how much penalties, how many crores can be levied, but unfortunately, that penalty goes into the consolidated funds of India. So India has 3 types of funds, right? According to the constitution, there are 3 types of funds that are there, but one of which is the consolidated funds. All of our income tax, all of that goes under consolidated funds. So under those funds, this particular whatever the data fiduciary is paying to the board will go into that fund. Whether we will get a compensation for the injury that we have faced or the damage that we have faced, not very clear. We might, again, only when case laws come, we'll know, but explicitly it is not given in the law. Future exemption is a possible threat that I am seeing here is, like I said, certain types of data fiduciaries can be excluded. For example, startups can be excluded from the law, like how in the GDPR they say that you don't have to have a DPO or record of processing if you have employees less than 250 in your less than 250 employees in your company, something like that, right? Similarly, here the government may come up with such kind of exclusions for certain classes, saying that these types of data fiduciaries who are belonging to these industries or in this SMEs or these, some specific categories, NGOs, for example, need not comply with the law. That is both good and bad, right? So the law has explicitly mentioned that soon there will be notifications on that. So we should be look out for that. Maybe NGOs can be excluded from the data protection law also, maybe not, right? We just have to wait and watch. The source of data being tracked, I already mentioned that, Article 14 of GDPR gives you the right to know from where the data has been collected from initially, more in the indirect data collection methods, but you don't find that as an explicit mention. We might be losing that in this particular case. Who's the regulator? Already mentioned, Data Protection Board. They're appointed for a term of 2 years, like how every parliamentary constitutional body has an appointment reappointment method. They also have something like that. Who is going to be that appellate authority, which is basically the court where you're going to take your cases to? It is going to be TDSAT, which is the Telecom Dispute Settlement and Appellate Tribunal, right? So they are the ones who are going to they are the ones who are going to arbitrate. They are the ones who are going to handle problems or cases that come with regulatory appeals. So, okay, I'm out of time, so I'm not going to go through this. This particular 3 slides talk about the comparison between the different evolutions of this particular act, like 2018 bill, 2019 bill, the JPC's recommendation, and what is currently there. Most of which I've already covered here and there, right? The reporting of breaches, scope and applicability. Like the first, it included physical data. Now it is only digital data is there. Like data portability was all once given, but now it is not there. The risk of harms was the specific mention that was there, which is not provided. Now you find those differences that are transfer of data, like I mentioned, a local copy was required in the previous bills, but now it is not there. So you find a contrast here. Okay, how many slides do I have? Yeah, 2 more. I'll probably just quickly summarize, Karthik. Please allow me a couple of minutes. I'll just quickly finish. So the concerns here is the state, which is the state of India, can take exceptions, which is bad, which is already being discussed in a lot of privacy forums. The state, which is the government, can have a lot of upper hand for surveillance, like how it happened in the US, right? So this Freedom Act had to come for taking care of the FISA regulations and all of that, the Information Surveillance Acts. So we will never know how it evolves. So some lawyers, some data protection authorities, the experts feel that this national security exception can be very widely used, which may violate our very own constitutional right to privacy, is what we are saying. Again, topic for another day. We already mentioned some of these already, but yeah, one concern that we can see is, since it's a blacklist model, for example, if you're transferring data to a country like, say, Vietnam or Cambodia or some other country like that, let's say the law there is not strong enough even as to the level of India, then you're sharing data to a country where data can be easily misused or mishandled, right? So that risk is there. Physical data can obviously be mishandled, that is one, and excessive repeated requests from principals is not regulated. For example, GDPR says if one person is repeatedly exercising their right to access, you can actually charge a fee, or you can not tell them something like that is there. Some provision is there, but this law is not vocal about, for example, I'm going to a particular corporate and I'm exercising my right to information. Next month, again, I give my right to information. Every 12 months, if I give my right to information, right? So how are they going to handle it? Whether they should handle it or not, it's going to put undue stress on companies or on organizations. It's something that that is potential from this law. What are the opportunities for auditors? Is this consent management is going to be a very important thing. Review of security measures, technical organizational measures, like you're already doing. Now we have to look specifically into personal data as well. Records management, validating contracts. No longer it is just about confidentiality, but about protection of personal data. You have to look into those clauses. Verification of parental consent. Independent data auditors for certain financial for the significant data fiduciaries, and how rights are being handled in an organization. Right, so I'm just giving it over to Karthik. I'm out of time, but yeah, that brings me the last slide as well. Yes,
Yeah.
Sorry.
Thank you. Thanks a lot. And just to add one point on the audit related aspect. One is, companies can look up the impact analysis, and then second aspect is that, it also comes down to, the SOC 2 compliance, or, the agreed upon procedure compliance, which can help you to give a comfort and assurance to your customers on how the data is being taken care. But prior to that, I think the privacy impact analysis will help you to understand which specific data or a group of data, would require to be, looked at, and what are the various security measures have to put in place, depends on the data, the classification accordingly. And now back to the Q&A. I think some of it, I think, Andrew, you've answered it. There are 5 questions from Mr. Ranganathan PK.
Yeah.
So do you want to probably take the question one? I think you already responded. Q2 and Q3, maybe you want to quickly take it up.
Sure. IT Act, Act, okay. Following all the personal obligations under IT Act. What responsibilities will be additionally into? Okay, so IT Act is again, I mean, this is Karthik can also answer better, but I'll just give in a couple of points from this perspective. Is Section 43A of the IT Act has been repealed by this TPDP. So that talks about, so the other provisions of the Act still remain. So if you're taking care of IT Act, you're most likely looking at the cyber security aspects of that, the protection of data aspects of that. But how personal data in terms of rights is not regulated already by the IT Act, and SPDI is taking care of sensitive personal data alone. So there's a gap that you can visualize between cyber security protection of all data and sensitive data on one side. So this is more about personal data, like anything, like I mentioned initially, the definition is huge of personal data has been very huge. So anything that classifies itself under personal data, such as your IP address, or it could be photographs. Photographs is neither, it is not sensitive personal data as such. Your biometric is sensitive personal data, but how do you protect photographs? How do you mediate social media companies? Right. So all of that is going to come under. This is going to be a bridging law, I'd say, between the IT Act and Sensitive Personal SPDI Act. So everything that is not regulated here is most likely regulated here, and the sectoral implications would still remain. Going back to your question 1 that you had asked, Ranganathan sir. So it will overplay. It's going to be an interplay of all of these regulations. So most the core focus area that we would look into is specific protection of personal data alone and rights, handling of rights of people. So right to correction, right to erasure, right to nominate. So those are some ways that you are specifically going to look into as part of this act. That's Q2. Q3 is Karthik, your points as well, please.
No, I think you briefed it. So the DPD is more to do with, as you rightly said, prayer is more to do with the harm that any individual may probably get into. With today's world of having the data being shared, personal data being shared on digital platform, most web aggregators share the data to the other one. So that brings some responsibilities required to be fixed in order to ensure how the personal information can be protected over and above your sensitive personal data, which is more to do with your the caste information or marital status, etc. I think the privacy bill was more focused to see, while we are moving towards a digital journey, a lot of information are also being captured on the digital platform, how the personal information can be protected. That was the whole concept behind where the security has been brought up. Yeah. Q3, maybe you want to answer?
Sure.
I think already you answered it. Yeah.
Yeah, just probably for the interest of that is, if you look at the applicability of law, it says if you're providing services, goods and services to anyone in India, even though you're located outside of India, this law will apply. So social media platforms based out of, let's say, US or Europe or any other country, if they target India, if they're made available for Indian users, and Indians can create, Indians in the sense those who are within the territory of India, if they can create an account, manage their profile, etc., that ABC Corp will now have to comply with the DPDP. That's the answer for Q3.
Q4, I think the answer is no. He has to seize the data, but Andrew, you can add further to that.
Sure. No, that's the beauty of consent. If someone withdraws their consent, you should not use the data further. It stops.
Correct.
That's as good as stopping data processing. If you are basing it on consent, if consent is the lawful basis, and if consent is removed, it is similar to turning off the engine. You cannot run that motor again. It just has to cease. But if you're looking at other deemed consent, so-called deemed consent or legitimate uses, obviously there's no consent there. So they have to object, they have to opt out, they have to, you have to look into other means of actually stopping processing. But it's based on consent and consent has been revoked, you cannot further continue processing the data. That's
any specific timeline being provided that they have to act when the consent has been withdrawn for them to?
No, that's not given in the law.
Q5.
Application to update. Yes, they definitely can. Okay. Okay, the law says this as well. In a manner prescribed, use the keyword in a manner prescribed. So that prescription will come later on from the government or the data protection board, such as how the right to correct should actually be handled, what sort of a form these data fiduciary should have, what data should be collected as part of the data correction request. All right, so all of that will come later on from the board, most likely from the board or the government, whichever the case may be. But yes, they can do it at any point of time. If you think a given data is inaccurate, such as you're moving your house and you want to update your records to a bank or to your employer or to anyone else who holds, you think under your RTA you found out that a given company is having your data, you can file a complaint to them at any point of time. There need not be a specific circumstance. It is your right at any point of time, but just as a data principle yourself, now your duties, you should not give false information. You should be giving verifiably authentic information. So that's the only caveat to that.
I think there's one question, Benita Mathur. So map of India and the background of the slash say may be corrected due to shape of GNK area. I think we'll take care of that, madam. Thank you.
Definitely.
Yeah. I think you're good. Yeah. Ravi sir, you want to have some final comments? Yeah. Okay, so thanks everyone. A great session, Andrew. I think a lot of questions and a lot of insights as well. And I know that we shoot 15 minutes, so probably even 1 hour additional also wouldn't have been sufficient enough for us to cover the whole of this topic, because Andrew had great he's an expertise in this area. So we want to share a lot of the practical scenarios and how the law can be interpreted and been applied as well. But nevertheless, we'll try to have one more session in the probably sometime later. Thanks a lot, Andrew, and thanks to the entire IIA team for organizing this and looking forward in the future sessions. Thank you.
Thank you, Karthik. Thank you for the opportunity.
Thank you.